All rise. The Workers' Compensation Court of Appeals is now in session. The Honorable Thomas Christensen presiding.
Please be seated. Welcome, counsel. It's nice to see both of you today. Welcome to the Minnesota Judicial Center for oral argument before the Minnesota Workers' Compensation Court of Appeals. Today's date is May 18th, 2026, and the court has one case scheduled for oral argument. Gerald Forcier, am I pronouncing that correct? Versus Steve Siding and Windows and American Family Insurance Company with claims administered by Sedgwick Claims Management Services, Inc., our file number WC 26-6635. Today's argument is being live streamed and recorded. We would ask counsel to speak loudly and clearly when addressing the court this morning. The panel for today's argument are myself, and to my left, Deborah Sundquist, and to my right, Judge Catherine Carlson. We have experienced counsel before us today, but as a reminder, you are allowed 15 minutes to present your argument with the yellow light going on, I believe at 3 minutes of time remaining. At the beginning of your oral presentation, you will be allowed 3 minutes of uninterrupted time before I cut off your argument to ask the panel if any member has a question for you. Counsel is requested to keep track of the time allotted for their oral argument. Any unused time may be reserved for rebuttal. Should the allotted time to a party be extended because of a questioning by the court, opposing times will also be extended for that reason. When you step to the podium, please identify yourself and the party you represent. Mr. Scully, I believe you're up first here today.
May it please the court, I'm Michael Scully on behalf of the appellant Gerald Forcier. The case before us for you today, this is not a case of a gradual worsening. It's a case where the true nature and the disabling extent of Mr. Forcier's cervical injury was unknown and not anticipated at the time of settlement. And only later did it reveal through failed fusions and permanent disability the nature and the extent of his injury. The respondents in their briefs seem to argue that Mr. Forcier needs to prove this case at this point in time. But that's not the standard that this court has set out. This court is consistent with the standard outlined in the brief that we've submitted that exercises discretion to vacate to achieve the basic objective and assuring that the injured employee, in Mr. Forcier's case, his compensation is proportionate to the degree and the duration of his disability. This court may vacate this for cause. And in our brief, it's been cited the Munson case. It includes for cause is the substantial change in the medical condition that since the time of the award and stipulation that was clearly not anticipated and couldn't have reasonably been anticipated at that time. In addition, the development of the new facts about the injury of Mr. Forcier's cervical spine injury, and even substantial discovery of facts existence, but were not known at the time when the stipulation for settlement was, the second stipulation for settlement was served and filed. And so it is our position there's a justification to vacate this award. As in the Munson case that we've stated, this is a case that Mr. Forcier's cervical condition was treated as a painful but management at the time. Nothing in the medical records prior, the first stipulation for settlement, as you're aware, was a dispute on the average weekly wage, but the second stipulation that was agreed to by the parties was a full, final, and complete with medical benefits left open. At that time, the condition of his cervical spine was painful but manageable. But the question is not whether anyone could have reasonably anticipated that. It is this that would evolve into a permanent disability and cervical a surgically refractory cervical condition that was not anticipated at that time. Yes, the medicals were left open, as you can see. And all of you have experienced when you're down here with us in settling cases where medical benefits were left open many times. But Mr. Forcier's anticipated issues were with his foot. He had that Liz Frank fracture, which is terribly disabling or painful surgically repair, and that was anticipated, but it was not anticipated of any cervical issues post settlement.
And Mr. Scull, let me interrupt you. We're 3 minutes in and ask whether Judge Sundquist or Judge Carlson have questions for you.
Yes, thank you, Judge Christensen.
Justice Sundquist, I got a cold affecting my ears.
Can
so
you hear me now,
I
Mr.
can hear
Scully?
you now, but thank you.
Mr. Scully, you have the burden of proof here.
I do.
Yes. I noticed there's a lack of evidence on a couple of things, and primarily dealing with the employee's workability. And to me, that is a major factor in fondness. There's nothing in the record that says he wasn't working. Was he working? Do we need to refer this back down for a finding on that issue?
My understanding is that he was working. It's my understanding.
When was he working?
At the time of the injury, and I believe afterwards, but it's one question I don't know. And I'm not making excuses, not my case. And it's a question that I anticipated when I was reviewing this yesterday, and I'm not sure if he was or wasn't working at the time.
Okay, follow up on that. SSDI, did he ever get it?
I don't know that either.
All right,
Right.
thank you.
Right. However, no, strike that. The medicals were left open, and it was when medicals left open. It was the additional issues would have been with his foot injury, the Liz Frank fracture.
And let me ask a question at this point. So we don't know if he has SSDI or not. We assume, given his age, is he receiving Social Security retirement benefits at this time?
I don't know that question either.
And kind of in conjunction with that, because you were talking about the medical, and that brought it to
Right.
mind, is
What?
whether or not Medicare has paid any medical bills related to his care and treatment.
I don't believe so, have paid any bills because, as you know, that there were two surgical recommendations and procedures subsequent to the stipulation for settlement. And both surgery issues were litigated in front of Judge Kelly, and both times the surgeries were awarded, and that the date of injury was a substantial contributing factor for the need for the surgery on his two surgeries on Mr. Forcier's low back.
And then it looks like there was a QRC appointed at some point in time, but that, even after the settlement where rehab was closed out. So I assume that was for medical management purposes, and maybe Mr. Schmeichel can answer that later as well.
The case was settled on a full, final, and complete settlement. And at that time, everything was closed out except future medical. I'm not sure what the QRC did at that time. The point is that this case settled on a full, final, and complete settlement. And subsequent to that settlement, there was a change in medical condition.
Well,
And this
Mr.
court-
Scully, I'm gonna interrupt you there because that's kind of where my line of questions goes. What troubles me about this case is what really was reasonably anticipated at the time of the settlement.
Mhm.
And from the limited information that we have, what I can see is on the same day that he signed the STIP, July 19th of 2005, was the day that he met with the doctor, at least according to the Gen X notes, to go over his cervical MRI.
Mhm.
So at the time of the STIP, he had the cervical MRI. He knew the extent of the findings. And I'm not a medical professional, but there's a lot of significant findings. There was no surgical request at that time, but he knew what the MRI said. More importantly, he also knew what his symptoms were. In the notes leading up to that, they indicate that he was eating ibuprofen because of his neck pain and his headaches, that he had right arm pain, that his neck pain was getting worse and worse. So again, although there had not been any surgical recommendations, this was not a surprise as to kind of what was going on in his neck. So both in the petition to vacate and your presentation here today, you say this was a condition that was unknown and unforeseeable. And I'm really struggling with that, given the information that we have, even in the limited records that we have. So if you could address that, please.
The stipulation for settlement was, as you said, signed in July of 2005. But when was the settlement? When did the parties reach the settlement? As we know, there's an extended period of time when we settle today. It may be some time later on, 2, 3, maybe even a month later. But at the time that, even though Justice Carlson, you point out what he was experiencing, those are symptoms, and taking ibuprofen. But there wasn't a surgical recommendation. That wasn't known at that time. And symptoms don't equate into surgery. The symptoms were manageable with that. No one had suggested any surgery. The focus on his injury was the Liz Frank fracture. And those are very painful and disabling fractures, or injuries, excuse me. But nothing was said at the time that surgery was needed.
And I agree with that. You had also discussed the Monson case, the Minnesota Supreme Court of Monson. And in Monson, when the employee settled, he was actually back to work.
Mhm.
In this case, again, according to the limited information that we had, he had not been released to return to work. He was off of work. And in fact, he was not driving.
Mhm.
So is there information that we don't have that he was working? And I think you've already told us that you're not really sure what the employment situation was.
I'm not sure that he was working. I just know that when he submitted to an examination that of our choice with Dr. Wengler indicated in his report that he was permanently and totally disabled as of the 2007 at that time when the second surgery.
And maybe you can help us out a little bit. And I know that in our questions, we understand you picked up this case and appreciate that.
That's
But
no problem.
what can you tell us? What happened after the settlement in 2005 to the present time, having to do with Mr. Forcier? Has he been working at all? Where is he living? We really don't
I
have an
know-
affidavit from him, so
I
we
know
don't know
he's
anything.
not working, and he hasn't worked at least since 2007. Now, when he stopped working, I don't know. But this court, as I can say that the whole medical condition, the medical care and treatment of the surgeries, the 2 surgeries that were performed, were not anticipated. And that, I think, is key to this. And I appreciate the court asking about the working, and my apologies for not knowing the direct time on that. But the medicals were left open, and they were left open, I think anticipation because of his left foot injury, but nothing was anticipated with the cervical spine. And
Mr. Scully, I have why now? I mean, it's been a long time. I'm just wondering, why are you bringing the petition to vacate now after 21 years? What was the rationale?
I don't know exactly, but there's no time limit in doing it. And I guess it was just, I can't answer that. I just know that this petition to vacate was filed, and I was approached and asked to take care of the oral argument on this. Mr. Olive, it was not available today.
Is Mr. Forcier living outside of the Minnesota area? Do you know where he resides?
Pardon me?
Where is Mr. Forcier living at this point?
Over in the Wisconsin area,
Okay.
over in the Somerset area, to my understanding.
All right. All right. Thank you.
So again, and I've said this a number of times, as in Munson, Justice Carlson talked about Mr. Munson went back to work, but at the same time, the pain existed at the time of each person's settlement. But in this case, again, and I've said this, I think the key is it's multi-level disc injury and the fusion. and being termed that he's permanently and totally disabled weren't known when the settlement was made. Mr. Forcier experienced as we talked about, these symptoms in his neck. Justice Carlson, you said about the time the STIP was signed and the award was signed, he was, getting, there was an MRI and all this advanced treatment, but surgery had not been recommended. How many of us have had MRIs to determine what's going on, but there's nothing beyond that? It's something to check. As I was sitting there looking this every day, when I look at my injuries that are in conditions that I've had over the years, I've had multiple MRIs, but have not required surgery or anything of that nature. And and going forward, he experienced these neck symptoms, and that doesn't defeat the petition to vacate. It's the disabling nature of the condition. The disabling nature of the condition occurred after this stipulation was served and filed. As Justice Carlson alluded to, the Munson case, the time of the settlement in Forcier, Mr. Forcier had symptoms, but no one knew that he was a surgical candidate. It was post-surgical candidate. The courts don't set a timeline that it has to be so many months or days or weeks or whenever there's a change in symptoms, but there were a change of symptoms, a change in his condition, and that change in condition occurred after the stipulation for settlement was signed, and it became known what the nature and the extent of his condition was. No one knew that he needed surgery, and that left him and leave him permanently disabled. And a statute exists for fairness that requires that. We look at the Fodness case, and those 6 standards that to assist in vacating: change in diagnosis, change in the employee's ability to work. But I'll move forward. We know those 6, but when you look at it, you don't need to have all 6. The diagnosis, it was a strained sprain at the time of the settlement, and subsequently there was a disc injury that required not 1 but 2 surgeries. His ability to work, Dr. Wengler, we're questioning, I'm not sure when he stopped working, but Dr. Wengler in his report said he's permanently and totally disabled as of 2007. There were 2 fusion surgeries. There's additional permanency. And the parties, when they contemplate settlement, they didn't anticipate the failed fusion. Lifelong disability or multi-level, the extent of the cervical injury. When you look at the settlement, and I would only be speculating, but what they settled that for, if this was settled for something more, to a greater nature where he'd be permanently and totally disabled, I think there would have been, if I would have settled the case, and I'm only speculating, and I'm out of time, Your Honor.
Go ahead and finish.
I may have would have settled it for some more money. Now that's way out here speculating. But as you know, if someone is anticipated to have multiple surgeries and anticipated will he go back to work, you might have settled the case using, whether he'd qualify for SSDI. His average weekly wage in the first step was just about $440 some odd dollars. If you take 2/3 of that, it's about $280. And you multiply that, by whatever number you want, and it comes to about what the settlement is. But if someone was anticipated to be permanently and totally disabled, there'd be that you would look at maybe the imputed average weekly wage for that date of injury, and maybe take into effect some of the other things that, that may be happening and going into the future to make the settlement reasonable. A continuation of
And then I think
symptoms.
we'll stop you at that point because I think you're a minute and 36 over. So,
Oh.
but thank you for your
Oh.
thank you for your presentation,
Okay.
Mr. Schmeichel. Since Mr. Scully went over a minute 36, we'll give you another minute and 30 if required. So 16:30.
Thank you, Judge. Much appreciated. May it please the court. My name is Jason Schmeichel. I represent Steve's Siding and Windows and American Family Insurance in connection with this matter. And it's been a while since I've argued on a petition to vacate, and I was thinking about it over the weekend. And one of the things that kind of jumped out at me is how remarkable it is as somebody who does district court work and work comp, the volume that we push through in work comp, whether it's claims reps, petitioner attorneys, defense attorneys, and judges. We deal with a ton of volume, all of us. And I don't have the exact number, but I'd estimate 95% of that is done via settlement. And I think that underscores the importance of having settlements that you can count on and rely upon, and that are reliable. And I think that that's reflected in the Fodness case and its progeny, and in the statute 461 regarding the setting aside of awards, making sure that this is very much the exception, not the rule. It's an unusual case where a stipulation is set aside. So what we are dealing with, and I think counsel outlined this, is that in terms of cause, I don't think we're talking mutual mistake of fact, not newly discovered evidence, not fraud. This is purely, as I see it, the allegation or assertion that there was a substantial and unforeseen change in medical condition. So looking back at the time of settlement, and some of this has already been discussed to a certain extent, I think it's important to Dr. Wengler and counsel, with all due respect, and the employee say, well, we were just focusing all on the foot. Everybody was laser focused on the foot. Yeah, I had neck pain, but nobody was really talking about that. That's not true. On the date of the injury, he had a CT trauma screen with findings, importantly, that included a loss of cervical lordosis, cervical spondylosis, and curvature abnormality. And the reason why that's important is that those very words show up in the operative reports that were conducted, was it 2007 and 2014. That's important. Dr. Kramer, shortly after that, but before the settlement, diagnoses the employee suffering from severe post-traumatic cervicolumbar and musculoligamentous brain strain with cervicogenic headaches. Again, that verbiage is important because cervicogenic pain and discomfort, both in the neck and the headaches, those also show up in the operative reports and the medical notes contemporaneous with the two surgeries that were conducted after that.
And we're at 3 minutes, and I'll ask whether Judge Sundquist or Judge Carlson have questions for you.
I do. Mr. Schmeichel, good morning.
Good morning.
Kind of following along with what I was asking Mr. Scully, the question of what could have been reasonably anticipated, and you're kind of outlining that right now. First of all, we have a settlement that's only about 7 months post-injury, right? So it's not, he's not at MMI for anything. No permanency has been assessed. And like I said, he had the cervical MRI on the day that he signed the STIP, or the results had been discussed with him on the date that he signed the STIP. My question for you is, how do we determine what can be reasonably known or reasonably anticipated about the need for future treatment or disability? Who makes that assessment? Is that a medical question? Is it for the three of us?
I think it's based upon, it's a tough situation because we're going back 20 years and we're trying to figure out what was in people's heads.
Right.
Kind of the same problem that we have when we used to try to rebut the retirement presumption. We have to try to get into the heads of the petitioner. But in this case, I think what they reasonably knew or could have known is important. And that actually gets to Dr. Kramer saying neck pain has not changed much from a subjective standpoint since beginning the program, where he had some injections and therapy. Severe dysfunction, but here's where I think it's important. The MRI on July 14, so right at around the time of settlement, discussed the risk benefits of the discogenic therapeutic epidural steroid injection, gave him only a 50-50 chance of having a reasonable improvement. You had cited this, Your Honor. He's been eating ibuprofen and really wishes to try anything that will help him take the edge off the pain. I think it's disingenuous to say that under those circumstances, with somebody who's eating ibuprofen, the doctors are saying you have a severe discogenic condition with pain in the right arms, headaches that are being caused by your cervical spine condition. Conservative treatment at that point, at the time of the settlement, had already largely failed. And the doctors were starting to tell him, we can try more conservative treatment, but that has a 50-50 chance at best. To say that under those circumstances that the employee didn't either know or reasonably could have anticipated that, hey, this isn't over. Maybe it's not surgery. Maybe I go in and I have other sorts of blocks. Maybe I have to wear a turtle brace or something like that. But it was clear, and it was and it's reasonable to to assume that at the time of the settlement, he knew that his neck problem was ongoing. It was significant, and he was going to have to continue treating for it. And the options that he'd been treating with at that time weren't working. And Judge Sundquist, in response to your questions, the I came down with a cold this weekend too, so must be something going around. Excuse me. In response to your question, the stipulation reflects that as part of the settlement, fees that were withheld were being released, and that suggests that there was temp total being paid. Also, it indicates that temp total was to be continue to be paid through the award on stipulation. So my understanding from that is that he hadn't returned to work at that time.
Mr. Schmeichel, any
yeah.
evidence that you're aware of that he ever did work? After
There
that?
is something in the record submitted, and I can't pull it out exactly right away, but it's cited in the brief, that indicates that there was a brief period of time where he did try to return to work. I don't have any, by that point, as counsel pointed out, there was no more voc rehab on the file. It was just medical management by Gen X. So there wasn't really anything discussing what happened in that return to work.
Did you seek discovery through this? Any deposition of the employee, for example?
No. The information, again, as pointed out by your honors, there's very little information at this point. And in terms of the ongoing vocational issues, it's odd that the only thing we seem to really have is Dr. Wengler, some 20 years after the fact, without indicating what records he received, what records he reviewed. Certainly he's not a vocational expert, but indicating that, hey, this guy's been disabled since 2007. I question the foundation for that. And perhaps if we had all sorts of other things to support the purported inability to work, then we could put Wengler on there saying, hey, in addition to all that, Wengler says from a medical standpoint, but that's essentially all we have is Wengler, a very conclusory statement. So then when we talk about the change in medical condition, counsel indicated that nobody knew what was going on. Well, they knew something was going on. The symptoms were there. They were there at the time of the settlement, leading up to the settlement. They were there after the settlement. And, the case law, particularly the McLeod case that we cited, which is the April 10, 2007 decision of this court, stands for the proposition of, among other things, that more treatment does not equal change in medical condition. There's also the Julie Hartzell case, which is 2017, also this court, which talks about the fact that one was interesting because that was also a Wengler report in that one. And what the Wengler and the other report in that case were talking about is that this is, an ongoing manifestation of this earlier problem, which is essentially a discogenic and degenerative disc disease. And so what we're seeing is the ongoing of that. That is what was discussed in the Hartzell case, where they were saying, but that's not a new diagnosis. That's a worsening of a condition that was either known or reasonably could have been known at the time of settlement. It's just gotten worse, which when you talk about degenerative changes, by the very nature and by the very definition, degenerative changes are going to get worse. As I understand it, Mr. Forcier is 70 years old now. I would certainly expect that even under the best of circumstances, that condition was going to continue to deteriorate. So when you look at the 2024 report of Wengler is actually saying this is, other than starting to include it at an adjacent level, which this court has actually talked about that too, saying that was in the Melius case, Melius, which is December 22, 2023, that it's reason that the court indicated they didn't make their determination. I don't want to mislead you. The determination wasn't made upon this, but they did note that degeneration at adjacent levels could have been reasonably anticipated. That if you've got a problem at one level, that's kind of the way that it works. So there's no new diagnosis. There's no uncovering something. I had a case that I took to the Supreme Court, and there was it was a neck injury, and it turned out some 35 years later, it was discovered that he had chemical meningitis from a panoplectic CT scan that they used to do back in the 70s. Now, there is a condition, and unfortunately, I argued that that was somewhat because he had the symptoms. There was a condition where the court said, no, nobody anticipate that he would have chemical meningitis. That certainly wasn't contemplated. We're not talking about chemical meningitis. We're also not talking about, also in the Melius case, that one was granted, the petition to vacate, but primarily because they said catastrophic surgical outcomes. The gentleman in that case, unfortunately, was rendered paraplegic from the failed surgeries. We have evidence suggesting in the medical records, as we pointed out, that in this case, the employee is far from paraplegic. In fact, he's riding around on mopeds and fell off one and suffered some injuries.
Is there how do we know he's right?
It's in the medical records. So assuming the medical records to be accurate, and those are medical records that were submitted in our exhibits, Your Honor, assuming that they're accurate, this gentleman is not paraplegic.
Mr. Schmeichel, when I was first looking at the STIP and, assuming that he has not worked since the date of injury or shortly after that, a fact that we don't know for sure, my thought is this settlement feels kind of light for his current situation. Should that factor in the kind of the like, boy, your predecessor, John Guthman, really got a good deal for his client. How should that feeling factor in, if at all?
First off, we should note that the employer was represented by Mark Olive, not a slouch in any sense either.
Agreed.
Your Honor, I would love to say that it shouldn't at all. It's arm's length bargaining, but I will concede that under that sort of overarching, the mention in the case law, that there is sort of an overarching thought of what's fair. But again, it's what's fair going back to what people knew or should have known at the time. If they understood or reasonably could have understood what the future might hold, then what's fair is what they bargained for, unless they meet the FODNess or the statutory factors. If they do meet those statutory factors, then it does sort of prove that maybe it wasn't fair. So that's how I think it comes into play, Judge.
Thank you.
Is this a case that, just looking at it, because we have unanswered questions as to employees' work, SSDI, retirement, things of that kind, is it a case that we could refer back to COF for additional findings of fact on those kinds of issues, or what's your position on
You
that
could
area?
probably anticipate where I'm going on this one, is that the legislature has decided that this is the forum for making the decision as to whether the burden has been met to vacate a petition, to vacate a stipulation for settlement. Of course, procedurally, if that's granted, then we go back and we start sorting stuff out in front of, if need be, in front of a compensation judge. For the purpose, though, of, because there are so many unknowns, I think at this point that goes to whether they've met their burden, which is all theirs in terms of the FODNess factors and the statutory factors. I don't think it would be fair to my clients to say they may have met it, but maybe not. Let's send it back and give them a bite at a trial, and then we can come back and decide it again. Procedurally, I don't think that that's how it should work. And I think I'm inching down towards the end of my time. And without opening up another can of worms, I'll leave it there unless your honors have any questions.
Any questions?
No questions.
Mr. Whitson?
By the way, Joe Toomey entered my office this morning reminding me he's a classmate of mine from law school, that today on the nose is our 30th anniversary of graduating from law school, which another classmate of mine from law school means that it's also Mike's 30th anniversary. Congratulations.
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 I told Joe to get out.
We have more years than you do, so.
We'll adjourn. We have 30 days to issue a decision. At this point, we're adjourned. Thank you very much. Or 90 days to issue a decision. Thank you, Judge Sunquist.
Mr.
Likewise.
I don't